Hello, this is Nathan Prescott here. Edward's out for a moment. That's some of the pleasure of live TV. I was hoping to do a shot like this. Hi, this is Law Focus with Edward St. Pay and my legal guest, Nathan Prescott. So I'm going to move to my normal seat. I'm not Edward, people. I'm just Nathan. But it's really nice to talk to you. Clarence is still in the back, and Edward will be here soon. Because Edward is not here, I still get to do whatever I want, and I'm going to say live from Ocean Springs. It's Law Focus. I do have a few questions from viewers, and I can go ahead and address those now while we're waiting for Edward. I think when Edward comes back, we'll be able to talk about COVID a bit and some other things, whatever is on his mind. But as it is a live show, people get stuck in traffic and people aren't able to make it. So today it's live from Ocean Springs, and happy to address some of the questions that I have received from viewers or will receive from viewers. So one of the questions that I've received concerns protective orders. So we're not talking about temporary restraining orders, but we're talking about protective orders that may be brought in court. So how do those things work? So what we have for protective orders is pretty simple. Let's just say that you're trying to get an item of discovery. If you're in a divorce case, you may need to get some kind of video or some kind of phone records. Or if you're in a land dispute case, you may need some land records or some documents concerning how much the sale price was. Or if you're in a trust dispute, you may need information concerning when was sold, to whom, and how it was sold, and whether there was a breach of fiduciary duty. So in order to get those records, you can subpoena them. And if you subpoena them and you use the power of the court to sort of reach out and grab everybody's assets or grab everybody's information. Well, in those subpoenas or in those requests for depositions or requests for interrogatories or requests for any other discovery mechanism, the opposing counsel gets to see that and say, hey, look, Nathan or whomever is looking for some very specific information. That specific information is somehow privileged or somehow not to be disclosed. So at that time, they file a motion for protective order. A motion for protective order is a document that says the information that you seek to receive can't be granted. We want to protect that information. And of course, as the issuing party, you're out there hemming and hawing saying, please give us this information. This information is vitally important to our case and the proof of our case and the admissibility of evidence and all other notions of fairness. So you get out there and you raise a ruckus concerning the protectivity or the protectability of the information. So that's what a motion for protective order is. Well, how does it resolve? Well, it resolves depending on the court's ruling. I've been frustrated recently. I've been pleased recently on how these motions for protective order go. You know, you ask for vital information, you ask for depositions, and then opposing counsel says, you can't depose my clients because the previous lawyer didn't depose them and now you don't get a chance. Well, of course, how are you going to advocate for your clients if you can't get that information? Well, you got to fight. You got to fight. And so you fight with the court and you fight with the opposing counsel in order to try to get the depositions, get the information. You see these motion for protective orders filed a lot in big cases. So you've got President Trump and his access to the tax records, or you've got AT&T, Singular, Cellular South, whoever it may be, and Apple protecting access to access to phone records. So those motion for protective orders, whether it be in the state court of Mississippi or a local justice court or anything else, could really come up in the day-to-day life. And obviously, that's what Law Focus is about. Law Focus is about, one, Edward's absence and us ragging him a bit for it, because Edward, this is a live show. We've all taken our time here, but I'm glad that I can entertain and hopefully educate the Law Focus crowd. We're happy to be here, and let's keep rolling. So thanks for that, Clarence. Clarence has always got my back right here. I mean, Clarence was here so punctual. I mean, he was so punctual. I mean, I came in, he almost swarmed me getting all this mic and makeup and everything on, so appreciative of Clarence. Clarence, so after we've talked about the motion for reconsider, I think that another thing that could come up is, well, what if the judge says no? Well, obviously you got appeals there, and we've been through the appeal process before, but all of these things cost money. So the client, of course, is sometimes disenchanted, like, well, what do I need to do? And that's when it becomes a lawyer's job or a client's job to make business decisions for the benefit of the client. The client has to decide whether to push forward or whether to stop. There are a lot of legal remedies, and there are a lot of lawyers you can put on a case, and you can put a lot of paralegals on a case, and you can make the case a beehive of activity. But if it doesn't ultimately benefit the client, or if the juice is not worth the squeeze, if there's no blood in the turnip, if, there's a lot of ways to say it. If there's no end game, if there's no financial end game, then you have to make some pretty tough decisions. Now, some clients and some litigants are in it for the blood sport, or in it for principle, or in it for principle. And cost may not be an object. They want to see justice done. They want to right some wrong that has aggrieved them or their family. They want to right some wrong that maybe their family has instilled upon them. In those kinds of cases, the law is there to protect. And frankly, in those kinds of cases where the cost is not a huge object, the law operates in a vacuum, and the law operates in a vacuum where everybody gets to put as much work into the case as they can. And sometimes you get the most just rulings in those cases because, frankly, there's not that hindrance of having to pay for it. And that's the capitalistic system at work, and that's how our system operates. Clients ask me all the time, am I going to get my attorney's fees out of this? The vast majority of the time in Mississippi and in America is no. Just no. If you have to ask, assume no. There's some chances in very egregious circumstances where attorney's fees will be granted, but in those circumstances, it's usually contractual and based on statutory law. If it's not in the statute, and it's not in the contract, and it's not very egregious, you're not going to get your attorney's fee. So I don't mean to dissuade people from seeking an umbrella of the courts or seeking the protections of the laws. But what I will say is attorney's fees, not very well granted. And that goes back to something that's pretty interesting. There's an English rule and an American rule. The American rule dictates that a litigant, whether victorious or not, bears his costs or her costs. Whereas in the English rule, it dictates that the victorious litigant, receives costs paid. Pretty amazing. So just in those kinds of systems, a lot of our system is based on English common law, but there's a very vital distinction. I'm not an English lawyer, but I'm a lawyer in English, I guess. But, that's a very vital distinction, and one that's worth contemplating. I mean, how would the system change if victorious litigants were to bear their own costs? I bet victorious litigants were to have their costs paid. I'm sure litigation would go down. But that's our rule here in the United States. It is the American rule versus the English rule. And because the American rule is there, you have to do a cost-benefit analysis when engaging in any kind of legal activity. So I think we're going to go to break. I sort of hear Edward rumbling around in the back. It was nice speaking to you one-on-one. We'll get Edward back in here and see if he's got any card tricks or maybe, I don't know, harmonica blows or poetry to recite, or I don't know. I mean, Edward's been in the business a long time. What he may come up with could astound. Thanks, Clarence. Let's roll to the commercial.
Dr. Timmons, tell us about your practice in downtown Ocean Springs.
Well, we've been here since 2006. We're a digital dental practice where we do digital impressions and Invisalign, same-day implant crowns, and guided implant surgery, etc.
So a person can literally come in and have the implants done in one day?
In one day. Sometimes people break a tooth off at the gum line, unfortunately, and we're able to extract that tooth and place the implant and place a crown in 1 2-hour visit.
Okay, what is the contact information? What's the most convenient way for people to reach out and make an appointment and get in contact with your dental clinic?
On Facebook, on our Facebook page, or timmonsfamilydental.com.
Thanks for being with us today on Ocean 7.
Thank you.
Hi, I'm Dennis Kynes with Sprout. Join me every Tuesday at 10 a.m. and 6 p.m. on Ocean 7 for Sprout Central, where we talk about all things business, how to grow your business and how to start your business.
Welcome back to the program. Of course, we're live.
COVID bump.
It's always nice to be live because it's a certain bit of, what is the word, adrenaline rush.
Yeah, and you're totally extemporized. So I just was answering questions for a moment while you were out, and so I had some questions, right? And there were a couple things I wanted to address. One of the things that I addressed earlier is sort of behind us. It's a protective order regarding depositions and things like that. You and I can talk about that after the show. But another thing that's really interesting, Edward, is, you know, people ask all the time, well, what about a temporary restraining order? What is that? Well, a temporary restraining order is something that can be put in place. Now, a temporary restraining order can be against an individual or it can be against a sort of a thing, you know. So a temporary restraining order can say, hey, business, you can't sell these baked goods anymore because they violate some kind of patent or trademark, you know, there's some kind of patent or trademark violation. Or a temporary restraining order can say, you know, Joe, you can't get within 20 feet of Susan for this period of time. Now, how do those restraining orders get put in place? People want them all the time. I need a restraining order for this. I need a restraining order for that. Well, they're very quick, Edward. You have to, I mean, the standards are pretty high. What you have to do in a restraining order is you have to file a motion for a restraining order in the appropriate court. A lot of times it's the Chancery Court here in Mississippi. Okay. After you file that motion for a restraining order, you have to go in front of the court pretty quickly. You have to prove that but for the restraining order, some kind of immediate and irreparable harm will likely occur. So it's not something that can be off in the woods. It's not some wolf in the woods kind of thing where you can say, hey, you know, this person might do this to me. I believe it. You have to really go in there and prove a substantial likelihood of immediate and irreparable harm. So in the case of the baker that I brought up earlier, you know, let's just say the baker says, look, this person is selling, you know, ho-hos that are exactly like mine. It's cutting into my bottom line, so it's immediate harm, right? But the judge may say, well, it's not irreparable because you can go out and, you know, you might can be able to compensate yourself after a lawsuit on that. Immediate and irreparable harm would be maybe some kind of threat of violence or something. You know, if we don't have some kind of separation, then we're going to have problem here. And after I'm injured, that won't be able to be repaired. So that's the kind of immediate and irreparable harm that we're talking about with temporary restraining orders, and that was a question that I get a lot. Another question that I get a lot, what if the judge screws up? So we've been over temporary restraining orders, we've been over protective orders, and what if the judge screws up? Can you bring his or her decision back to them without going to the appellate court? Yes, you can, and you know, we have to do it sometimes. It's called a motion to reconsider. So a motion to reconsider is provided in the Mississippi Rules of Civil Procedure, and what you can do in those things is if you feel like the judge has a substantial error, and you can pinpoint that error, right? Maybe there's some new evidence, maybe there was some fraud on the opposing counsel, maybe, you know, justice demands the reconsideration. You can file a motion to reconsider in front of that judge. And that's strange, huh? So you get a bad ruling, you file a motion to reconsider. How well do you think that goes over? Not so well, because the judge has already deliberated over it and hopefully made a pretty sound ruling. So when you bring it back in front of them, what you do is you put your suspenders on, then you put your belt on, you do everything you can to hold your pants up tight, and you just get in there and try to charge for your client, because it is quite difficult. You've made all these arguments, you've written all these briefs, the judge has ultimately ruled. After the ruling, you say, no, come revisit this again. We want you to really, really shove your face in this mistake. They don't like that.
I wouldn't imagine, because the judge is, you know, the ultimate.
Yeah, that's the
judge. You know?
Yeah, they would sometimes say, yeah, she's a judge. They would sometimes say, you know, just take it to the Supreme Court. But frankly, you know, an appeals process in the Supreme Court could take up to a year. Whereas if you got a bad decision in the local court, I'm dealing with this now, if you got what you believe is a bad decision in the local court, you get a motion to reconsider in front of them within 10 days, 10 to 30, you file it within 10 days, and you can get it heard sometimes within 30 days. Now, usually, you just totally burn Rome, and you go down like the Hindenburg. It's a terrible circumstance, right? You're just pleading. You're saying, Judge, don't sanction me. I'm sorry for that motion to reconsider. So you choose them very wisely because you use a lot of capital filing them, right? The judge really doesn't like that. But, I mean, I'm not here for judges. I mean, I respect judges. I honor their rulings. I act within the dictates of the Mississippi Rules of Professional Conduct. But my job is to advocate for my client. And if there's a chance where I think the judge is wrong, I got to advocate for my client. I mean, when you swear your duty to do this job, you're not doing it for yourself or for the judge. I mean, you're doing it for the law, but you're really doing it for your client. So the client pays you, and you're like a wind-up toy, right? You just get out there, they wind you up, and then you go and you advocate as hard as you can. Now, why wouldn't I file a motion to reconsider every time? Because sometimes, there's just no footing for a motion to reconsider. Or sometimes you file a motion to reconsider, and the judge is sanction happy, and you get sanctioned, and you and your client are in trouble. So there's time.
So if you get sanctioned, what happens then?
What you do, Edward, it's like when you go to the gas station or when you pay your mortgage, you just pull out your checkbook and then you write a big check, and it's painful. Right.
So in other words, you would be fined?
Yeah, they'll fine you.
They would fine the attorney or the client?
Well, they could fine both. And then that's a really fun discussion that hopefully some of the lawyers that watch the show, and I want to give a shout out to the people that have seen me in the local grocery stores and at the gas stations and at the restaurants, to the extent that anybody goes to restaurants anymore. Go to your restaurants and be safe according to the CDC guidelines. But thanks for watching. Thanks for saying hello. We totally appreciate it. It makes me feel cool.
Well,
I mean, we all have egos.
I've learned something today that I didn't know about sanctions and all of this, actually.
Oh, yeah, the sanctions are serious. So it's a dance. I mean, people will threaten to sanction me for stuff that will really put a substantial hardship on my finances. You're going to be sanctioned for, like the cost of a couple Camrys,
How much would the sanction be? Could it be?
I mean, people will ask for $100,000 worth of sanctions.
The judge would ask for that?
No, the opposing counsel will at times.
The opposing, $100,000?
Yeah, oh yeah, when these cases get really big, they say, because you did this or that, you owe me $60,000 worth of sanctions or whatever. Now, it's very, very rare for it to get that serious. But, a $5,000 sanction can happen, a $10,000 sanction at times. You have to be cautious. It's like, if somebody builds race cars, right, and you know that you could spend all that money, and the more money you spend, the faster you're going to go. I mean, if you had enough money, if you're like Elon Musk or Uncle Jeff Bezos or whatever, you could build a super fast race car, right? You could build it so fast that it would be dangerous. Well, that's sort of how sanctions are. Like, if a client wants to pay, you can push and push and push and push, but like the race car, sometimes you're going to explode. I mean, they'll sanction you. So as a lawyer, you've got a duty to your client, but you've also got a duty to uphold the law, right? And you got a duty to be an honest relayer of the facts to the court. So, so I say, if you're not rubbing, you're not racing. You're trying very hard to advocate for your client within the realms of the Mississippi Rules of Ethics. The ethics rules are sort of the, that's the pole star. You get the ethics rules, you learn the ethics rules, you operate within the ethics rules. But once you get those rules, right, so nobody criticizes a chess player for an en passant move or castling the king, or moving the rook over, operating within the game board. People criticize and penalize a chess player for being a petulant ass and throwing the pieces or moving the pieces improperly or playing with outside of the rules. But the Mississippi Rules of Ethics and the law give you that chessboard. They give you that construct within which to act. And once you have that construct within which to act, it's your job to get those pieces to the checkmate as hard as you can every day. So if you have to think about it a little extra, you think about it a little extra. Or if you have to, you know, tease one option by moving your queen out to open up another front on the other side, then you do it. It's a pretty intense match. It's a pretty intense professional match. And this is something that I tell a lot of clients that, you know, you may have heard what the opposing counsel is like. He's a bulldog, or she's a bulldog, or he's, you know, he's overworked or understaffed or overstaffed, or they got a big firm, whatever. I just got to tell you, they all sat down for the most part and passed the bar, and they all want to win. So when you get two chess players fighting, things happen, especially when some of the rules are nebulous, because the judge gets to make the decision. I know when I win a chess match, it's very clear, right? You know, you've checkmated the king. There's no way around it. The rules were followed, the king is checkmated, that's the end of the victory. Or if you play video games like Super Smash or something, you know when that is over. The character falls off the stage, everybody celebrates, and that's the end. But in the court, you don't know exactly where the win is, right? The judge sort of can change the win a little, because a judge, like you, is human. And humans err and are successful. Humans have rational desires and irrational desires. So you have to navigate all of that. Pretty interesting stuff.
So it's good to stay on the right side of the judge.
Yeah, but there's no right side, right, Edward? I mean, it's good to stay on the right side of anyone, I think, that you interact with. But everybody's got different motives, right? I mean, the motive is the application of justice to these things. But one judge may interpret something differently. So your job, I think, as a lawyer and an advocate for your client, is to predict what the judge will do within the realm of the law. You know, and the judges, there's a lot of times that it's black and white, but there's a lot of times they have a lot of discretion. And it's good for you to note what a judge does in certain circumstances.
Certain judges are known for being
lenient,
this way
or that way, yeah. Or how they like the briefs presented, whether they encounter oral arguments a lot, what kind of evidence they let in, what kind of discretion they grant to one party, to plaintiffs or defendants. I mean, judges would like to be perceived, and many times are, like rational machines. But to make a judge a rational machine would be able to would steal some of the humanity from them, right? Because none of us are machines. We all have interests and desires, and we all went to school and learned different things in school. We all have focus points. We all have egos to protect. We all have things that we're doing out there in the world that inform our decisions. But for a judge, his or her decision affects others. So that's why we elect them, and it's important to elect judges that you think will make decisions both that comport with the law, but also sort of reflect, I guess, you know, reflect your ideal of a rational decider.
I think you would make a good judge.
Oh yeah, well thank you for that. I just enjoy the practice so much though, right now.
Well, yeah, but in time, over time, you may decide.
I plan on, you know.
You would like to do it, who knows?
Who knows what, you know, the actuarial rates, the life expectancy. I think I got a little more juice in me. We'll see what happens. I'm enjoying it day to day.
As the juice starts to kind of settle down, then you might decide, well, now's the time to become a judge.
Yeah, who knows?
Who knows?
Who knows, man? It's fun. That's what life's about, right? It's that sort of ebb and flow and getting to decide. We know we are in fortunate and free positions where we do get to decide so much. That's cool. Let's talk real briefly before we roll out. It looks like the time is running tight, but schools are opening. Did you know that?
Well, I've heard they were.
I've heard they weren't.
You heard they weren't?
Well, no, I didn't know. Well, it just depends every day.
Yeah,
I don't know what papers. It's hard to get the scoop. I read the Sun Herald, I read the Clarion Ledger, and I read an online publication called Mississippi Today. So I try to get a little piece of each of those and try to find out exactly what's going on. This morning I was able to read a few papers, and it looks like the schools are going to open, but every district may have a different way to open. So for instance, we're here in Jackson County. I believe Jackson County is going to require the opening, but then allow kids to opt out and do virtually if they want. Did you know that?
I didn't know. I did not know that.
See? Law Focus, here to inform. So what's the legality of that? Well, the schools, the mandatory education was deemed legal right? So you got to educate your kids. That's societal welfare. Allowing them to opt out or making this construct out there is part of the government's wing, and allowing them to opt out. If something says, hey, if you want to opt out, you can opt out. You can go home at school. You know, there were a lot of moms out there that were really concerned about COVID, right? Come in March and April.
Right.
Right. I mean, they were just terribly concerned. Everybody needed to be home and stuff like that. Now, all these moms and dads, parents, have been with their kids all summer. So I wonder if they're as concerned now, you know, because the kids, they can still opt out. So, you know, I don't know.
Now that all the mothers have become alcoholics.
I'm just saying there's been a lot of at-home time with the kids for all parents this summer.
Yes.
And I will say that COVID is more present now in Mississippi than it has ever been.
Yeah.
So are we going to send the kids back to school? It's a tough decision for parents, and one.
But the children are not as prone to get the disease or suffer.
You're saying we know? Yeah, we know more about it now.
Yeah, we know more about it. I can understand everybody's concern.
Me too, and I don't think, I was talking to a friend this morning about it, I don't think that there is a, shout out to Jason Gray, I don't think there's an end in sight. I don't think there's an easy solution, you know. He was talking about like what he was going to do with his kids and things like that, and, you know, I don't think there is an easy answer. So it's interesting. So we got schools going back. We got some mandatory masking in the public now. We got yesterday I was in court, there was no groups larger than 10. You know, there's just a lot of stuff going on.
Seems like the masking is a big thing. That's a good thing.
Have you been wearing one outside now?
I have been, yeah.
Yeah, me too. I'm getting used to it. We wear them in our office now. We're really interested in complying with CDC guidelines, and we just do that. Oh, one thing that's so pertinent from our last show is we asked a pretty important question: whether we as citizens abide by the law because it's enforceable, because we can get punished, or because it's the law, right? Well, it doesn't seem like a lot of Mississippians, or some Mississippians have, but some Mississippians have not been honoring the mask mandate. So now we have a hotline, a snitch committee. You know that? So if you go into a restaurant or you go into a place that is not following CDC guidelines, is not following the governmental orders concerning this, then you can call a hotline and then leave a message, and they're going to get back to you within, you know, when the vaccine's out. Now, I don't know when they'll get back to you. I've got no idea as to whether it's enforced or not, but there is a hotline.
But what did they do?
I don't know, Edward.
Drop everything and come over there?
Yeah, I don't know, Edward. Is it like immigration and customs enforcement? I mean, is it like a bunch of ICE agents?
Take you away.
I don't know, Edward. I'm just telling you that there is a hotline.
Yeah.
So at least there's some
teeth.
Some thread of teeth.
A threat of teeth.
A thread of teeth.
A tooth.
A tooth. Yeah. So there's a tooth out there that you know. So yeah, don't call a committee on me. We're fine here. It's only 2 of us people, so we're enjoying it. We're enjoying it.
Well, Nathan, thanks for running solo for the first segment.
Oh, I like this. It was good.
I thought that if anybody can do it, you can do it.
I appreciate that. What I would like to do is, you know, keep the questions coming. If there's any questions out there that you'd like us to address, we're happy to address them. There's been some Supreme Court rulings recently. We'll talk about those. We'll also talk about, it seems like we got a good response to just the practical day-to-day aspects of the life of the law. So we're going to keep hitting you with episodes, and we're totally pleased to do it. Give me a call if you need anything.
Okay, thank you. And thank you for being with us, and we'll see you next time on Law Focus.